Hi, everyone. This is Joe Adams here. I am a U.S. immigration attorney based in Los Angeles, and I spent a fair amount of time in New York City, two major immigration capitals of the United States. Uh, Breaking session today. For those of you who are able to join us live, please feel free to ask any questions you'd like. The best part of these sessions, which I hold about once a month, are the questions. You guys always have much better questions than I can think of. So just type your question in the chat, and I promise I will do my best to get to all the questions. Today's a little bit unusual. Normally, I have a few topics that I want to go through, and usually the questions will guide the discussion. Bit of housekeeping. For those of you who cannot attend the entire session, no problem. I'll record this session and then I'll send a video copy on YouTube to everyone who registered. And if you have friends who missed it, feel free to pass on the link. It'll be a publicly accessible link on YouTube. First part of today's session, we're talking about adjustment of status. We're going to get into what adjustment of status is, why it's important, and what was the big announcement that has caused a lot of concern. And like many things that this administration does, they make the big announcement on a Friday before a holiday weekend, catching everyone off guard. I was at a dinner with friends Friday afternoon when this announcement takes place, and within minutes, my phone is blowing up. What is this? What does this mean? What does this mean for my case? And then after we're sort of at the adjustment of status discussion, and then we feel like we can move on, I'd like to open up the session to any other questions you might have about immigration law, policy, rumors that people have heard. Uh, Immigration law, unlike other areas of the law that I've practiced in, is full of what I call well-meaning and misinformed friends. Oh, my friend did it this way, so shouldn't I do it this way? Or my friend's dad's a lawyer. He practices real estate law in Germany, and he thinks the immigration law in the United States is dot 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 dot. So dispelling rumors is a big topic of conversation for me. Okay, the first topic, the topic of the day, adjustment of status. There are two different processes procedurally by which a person becomes a lawful permanent resident of the United States. A lawful permanent resident, or LPR, is sometimes called a green card holder. The word green card is a slang term. It refers to the physical color of the card stock that they used back in the 1930s. Green ink was hard to manufacture, so the government felt if we print the cards in green, green ink is hard to manufacture. It'll cut down on counterfeit. That's literally how why they are called green cards. The fact that they are green is irrelevant. Now, of course, a green card is a plastic credit card sized document, lots of security features, anti-counterfeiting features. Your fingerprints and your image are encoded in a magnetic strip. That's the physical card. Like a driver's license or like a law license or a license to practice medicine, the physical card is not super relevant. Here's my California driver's license and here's my California bar card. If I lose these physical objects, I am still a licensed attorney and I'm still licensed to drive a car in the state of California. It refers to a legal status, okay? Green cards, lawful permanent residence. I like all three of those words. Lawful meaning undocumented, as opposed to undocumented. Permanent meaning that you're making the U.S. your home on a permanent basis until you die, until you naturalize and become a U.S. citizen, until you commit a very serious crime and get deported, or until you abandon your immigrant intent, move home with no plan to return. Becoming a lawful permanent resident, becoming an LPR, can be your final destination in your immigration journey. There is no requirement that you become a citizen. No one jumps from no status to citizen. You always become an LPR before you become a citizen. Contrast LPR status, green card status, to visas. Many of you who I can see on the attendees panel on my screen, many of you are my clients, and some of you are my prospective clients, and some of you are people I haven't met yet. If you have a visa, you have a temporary status. So different visas have different rights, responsibilities. A B1, B2 visa is a tourist visa. You can go to Disneyland. You can negotiate a business contract with your US counterpart, say if you were a bank executive. An F1 visa is for students in a course of academic study. An H1B visa is for technical workers. An L1 visa is for intra-company transfers. It's how we move executives around internationally. An O1 visa is for persons of extraordinary ability who can show the government that they have a very high level of ability. Each of those visa types are different because they have different rights, different requirements, different lengths of time. But they all have one thing in common. They all have an end date. A visa has an end date, which is fixed. You can look it up online. You should be if you have a visa, you should have an I-94. If you don't know how to look up your I-94, raise your hand and I'll send you the link so that you can look up your I-94. Every time you enter the United States, every single time you're issued an I-94, and if you're not, you need to get that fixed. An LPR, a lawful permanent resident, is a permanent resident forever. Okay, visas are temporary. Green cards are potentially forever. The card itself is usually printed with a 10-year period of validity on it. Like my driver's license, like my California driver's license, it expires in 2027. Okay, I got to get it renewed next year. No big deal. I'm still licensed to drive my car. Um, why do I say that? Because if you're currently in visa status or going through a visa status, this rule change does not directly apply to you. If you are pursuing adjustment of, if you are pursuing a green card, this might impact you. Okay, there are always two steps to becoming a green card holder, to becoming a lawful permanent resident. Step one, you need a classification. The two common kinds of classifications are family-based and employment-based. Family-based might be a case based on marriage, or marriage to a U.S. citizen, marriage to an existing lawful permanent resident. The brothers and sisters of U.S. citizens, they have a long way to go, but brothers and sisters of U.S. citizens can request a classification. File a form called a Form I-130. That locks in what's called your priority date. That's your place in line. There's also employment-based classification. So you might, I know that some of you, I could see some of you on this call are pursuing or have pursued employment-based classifications. There are 5 employment-based or EB category green cards: EB1, EB2, 3, 4, 5. EB1 is for persons of extraordinary ability. They're self-petitioned. EB2 has 2 flavors. One is sponsored by your employer who goes through a labor certification process. The other is where you show the government that it's in the government's interest to waive the labor certification. EB3 is sponsored by the employer. EB4 is for certain religious workers and translators. And EB5 is the big investment-based category. So big picture, you get a classification either based on a family relationship or an employment relationship. You get your priority date, your place in line, by filing an I-130 for family-based or an I-140 for employment-based. None of that has changed. None of that's different. That's been the law since 1991. I wrote a book about the subject. They wrote these rules in 1991. They have not, they, meaning Congress, has not changed these rules since 1991. Congress has not changed these rules since 1991. This rule change is not an act of Congress. It's not even a formal rulemaking. It's what's called a policy memorandum. In the order of what of law, what is the highest law of the land? The U.S. Constitution. Below that, acts of Congress, the U.S. Code. Below that, Congress can delegate to the government. Congress can delegate to the president and his or her deputies rulemaking. How much arsenic is safe for drinking water? How much CO2 should be allowed in the atmosphere? Usually, Congress doesn't write that level of detail. They assign that level of detail to the agency. Sometimes Congress is very specific. Sometimes Congress is very vague. In the case of immigration, Congress created in the Immigration and Naturalization Act adjustment of status. Adjustment of status is a procedural mechanism. Uh, so let's go back. You want to become a permanent resident of the United States either through a family relationship or through an employment relationship. You file your I-130 or you file your I-140, and then now you're ready to go to the next step. In the old days, back when travel was very expensive, when my ancestors came to the United States in the early 1920s, that was a one-way third class ticket. They life savings, they're not going back. Travel was expensive. Travel was rare. What you would do is under the precursor to the INA from the 1950s, you'd file a family-based petition, and then the petition would be approved here in the United States, and then physically transferred to an embassy or consulate abroad. So say your family lives in Milan, Italy. Your relative has sponsored you here in the United States. They would file their paperwork. They transfer the case over to the embassy. That's what's called consular processing. In modern consular processing, which is still very frequent, we use it all the time. We file paperwork with USCIS, which is part of Homeland Security. We file the I-130 for family-based or the I-140 for employment-based. USCIS, U.S. Citizenship and Immigration Service, decides do they meet the criteria or do they not meet the criteria? If the answer is yes, the application meets the criteria, the application's approved, then the application is transferred from Homeland Security to the U.S. State Department. The U.S. State Department oversees the U.S. embassies. The U.S. Embassy then creates a file. We upload documents, a police certificate, birth certificates, if there was a divorce, if there was an arrest history, anything like that. We upload the case to a secure server that the State Department maintains, and then once the case is documentarily complete, then the applicant is put into a scheduling queue, and then when the scheduling queue when it comes up, the applicant is sent for a medical to make sure their immunizations are up to date and some other medical issues. It's not like a regular health checkup. It's a specific immigration medical exam. And then there's an actual in-person interview. At the end of the in-person interview, uh, uh, presuming everything goes smoothly, the applicant is issued a single entry immigrant visa, which allows them to come to the United States as an immigrant. The act of entering the United States as an immigrant registers them as a permanent resident. The green card itself is usually printed a few weeks later, and then we're done. Okay. In the 1970s, 1980s, as travel became more common, the government said, hey, let's make this a little easier for people who are already in the United States. Say, for instance, you were a temporary worker who's come to the United States on an L1 intra-company transfer visa. Say you were a bank manager in London and you had transferred to work at the New York branch office of the London-based branch. You meet your sweetheart, you fall in love, and you say, and the government says, rather than sending you through that process through the embassy, file the I-130, get that approved. But rather than go through the process via the State Department, through the embassy, let's go through a USCIS field office here in the United States, same medical, same very similar interview. And then at the end of the interview, presuming everything goes smoothly, Mr. or Mrs. Applicant, your petition's approved. A few weeks later, the green card is actually approved. Same idea for employment base. Say, for instance, you are here in the United States on an O1 visa. Say you are a high achieving social media influencer with a big following, and you're making good money and you're well received in your field. We file an I-140 under the EB-1 rules. The government's satisfied with that, and then you're in the US on your O1 visa. We file the I-140, get that approved, and then we can file your adjustment of status, adjusting you from your O1 visa into the green card. No embassy involved, no reason to leave the United States, no extra expensive travel or anything like that. That all sounds great. Now, we have an administration that is hostile towards lawful immigration, but they do not have the political wherewithal, influence, power to change any immigration law. If Congress wanted to, Congress could take the number of green cards and make it as many as give a green card to anyone who wants one. When my ancestors came over, it's in my social media. It was a one-page form. Uh, we could also do like Japan does. There's no immigration policy. Congress could set a law that says there are no green cards. We have a different process. There's about 650,000 green cards that get issued per year. They're assigned by different preference categories, family-based, employment-based, and then subcategories based on the kinds of relationships we have. Okay, so where does that bring us to today? What late on Friday, and I'm going to show you, I'm going to do some show and tell. Late on Friday, we immigration lawyers and anyone else who signed up got this email from USCIS with a press release saying they're announcing a new policy. And I'm sorry, I'm going to read this a little bit because I want you to hear the exact language. A new policy memo reiterating the fact that, consistent with longstanding immigration law and immigration court decisions, aliens, foreign nationals, human beings seeking to come to the United States, seeking adjustment of status, must do so through consular processing via the Department of State outside the country. Officers, meaning USCIS officers, are directed to consider all relevant factors and information on a case-by-case basis when determining whether an alien warrants this extraordinary form of relief. I'm going to skip this quote because it is just garbage lie. I'm sorry. You can read it for yourself. I'll put it in the email summary. It's just a press release statement saying that adjustment of status is extraordinary. So then it links to what we call a policy memorandum. A policy memorandum is instruction to the employees. Imagine you're the CEO of a company. The company issues a directive to all the workers in the company. The company can't change what another company does. The company's CEO can't change the law that governs securities or whatever the issue is. All the company can do is direct what its employees are supposed to do. And it might be illegal, and it might be wrong, and it might lead to litigation, and we're going to cover that in a second. So that now I'm going to show you the policy memorandum. This is the policy memorandum, and I'll send you a link to it in Dropbox after we hang up. So this is the policy memorandum that came out. Now, let me tell you, the normal way policy memorandums are drafted in normal days, the administration would come out with a they might call it a listening workshop. They might call it a roundtable. They might say, we're thinking of changing a policy. Here's our concerns. We, the government, have been studying something. We have a concern. Let's get all of the stakeholders together. And I've participated in this in the past in prior administrations. We want to hear from academia. We want to hear from the labor movement. We want to hear from the private sectors, private lawyers like myself. We want to hear from industry leaders. What are your comments? Is this a good idea? Is this a bad idea? What are you thinking about that we haven't thought about? And sometimes they come up with what's called a notice of proposed rulemaking, a formal process to make a new rule. Then there's what's called a notice and comment period, where there's a formal period of time to make your comments. The government must address those comments, and then they can issue a final rule. And then the final rule might be subject to litigation in court. The government might not have followed the process correctly. The government policy memorandum or rulemaking that follows might contradict what Congress passed. This is a preview of what I think is going to happen. So here's this policy memorandum. None of that process had been followed. No one was talking about changing the rules for adjustment of status. This was not on anyone's radar. So the policy memorandum is dated May 21st. That was last Thursday, but we didn't know about it. Then that press release comes out on Friday, last Friday, the 22nd. Like I said, it's a 6-pager. I'll send it to you. I went through and I highlighted what I thought were some of the more interesting and important sections. And again, I apologize for reading long sections to you, but I think it's important. Congress established significant limitations on the abilities of aliens to adjust status that do not apply to aliens seeking immigrant visas and admissions from outside the United States. Most aliens seeking discretionary adjustment of status under that code section, which states that their status may be adjusted by the Secretary of Homeland Security in his or her discretion if they are present in the United States after having inspected, admitted, or paroled into this country and are admissible to the United States for permanent residence, along with other requirements. As a result, aliens physically present in the United States who have not been inspected or admitted are generally ineligible to adjust status. In plain English, what that means is if you entered through an airport, if you entered through the land crossing, you could potentially be eligible to adjust status. If you walked across the desert and evaded normal processes, you have never been eligible to adjust status. That is one of the biggest areas of immigration law where me as an immigration lawyer, it's a roadblock. If I meet someone who might be in the most lovely bona fide marriage, they've been married to a U.S. citizen for many, many years, they have children together, they're productive members of society, but they walked across the border or were smuggled in a shipping container, they are not eligible to adjust status, and I don't have a solution for them. I don't have a good solution for them, at least. But everyone else, you came in an airplane and you were admitted. You drove across the border and were procedurally admitted, procedurally regularly admitted on any status, B1, B2, F1, O1, humanitarian parole. Even when aliens have been inspected and admitted or paroled, Congress has placed additional limits on their eligibility to adjust, which do not apply to aliens seeking immigrant visas and admissions outside this country, further evidencing a preference for aliens seeking to immigrate through the ordinary immigration process from abroad, through consular processing. The adjustment of status section of the code lists many classes of aliens precluded from even assessing adjustment of status, despite otherwise proper inspection and admission with certain limitations. This is going to be a big area of litigation because it's quite a misstatement of the law. Aliens may be paroled into the United States temporarily. So, say for instance, we do what's called humanitarian parole or TPS status. Remember, there was that giant earthquake in Haiti, and then the president was assassinated. people who are in the United States were admitted under humanitarian parole. That's what parole means. Aliens may be paroled into the United States temporarily on a case-by-case basis for urgent humanitarian reasons or significant public benefit. Paroled aliens, when the purposes of such parole shall, in the opinion of DHS, have been served, are expected to depart the United States or return or be returned through deportation to the custody of Homeland Security. Aliens may be admitted to the United States as non-immigrants from such time and under such conditions as DHS prescribes to ensure that at the expiration of such time, upon failure to maintain status under which he has been admitted, the alien will depart from the United States. Here's where I think they're getting at. There is a mechanism which I will never advise. I want you to just bear with me. The normal process, say you and your sweetheart are living in Paris, France. You're a US citizen, say you were working temporarily in Paris, you meet your sweetheart, you fall in love, he's a French citizen. Um, the way you fall in love, you get married. The way you get your French citizen into the United States is through the I-130, through consular processing. There are lawyers, unscrupulous ones, and there are helpful but misinformed people online who will counsel you to do what some people I have heard call the cowboy approach. I don't call it the cowboy approach, I call it immigration fraud, where a person enters the US either under an ESTA, the visa waiver, or they come in under a B1, B2 tourist visa. They pretend that they are coming to the United States for tourist reasons or business visitor reasons, but they have a secret plan to adjust status. Why do they do this? It saves time, it saves money. Maybe there's lack of knowledge about what we call immigrant versus non-immigrant intent. Maybe they're trying to cut corners, maybe they're trying to save costs. It is not something that I ever advise. And when I have clients or potential clients who come to me and they say, "Oh, I talked to this lawyer," and they said, "Well, you don't bother filing I-130, just come to the States and adjust status. Just come as a tourist, say you're going to go to Disneyland, and then adjust status." And that's one of those moments as a lawyer where I shake them by the lapels and I say, that is immigration fraud. You cannot tell at the border if you are telling the immigration officer you're coming to be a tourist and you are not coming to be a tourist, you are coming to apply for an immigration benefit like a adjustment of status into a green card. That is entry fraud. You may be in a perfectly bona fide marriage. Your marriage isn't fraudulent. Your entry is bogus. That's where I think this memorandum is really trying to aim itself at is at people who are attempting to do what some people call the cowboy approach, what I call entry fraud. Um, Generally, when non-immigrants or parolees fail to depart as required and then instead seek adjustment, it contravenes congressional expectations, though USCIS acknowledges exceptions, including non-immigrant categories with dual intent. So, for instance, if you're in the US on an O1 visa, an H-1B, an L visa, those are dual intent. When you come to the border on a B1, B2 tourist visa, you're saying, I'm here as a tourist, I'm going home at the end of my stay. When you come to the United States as on an immigrant visa, you're saying, I'm coming here to be a permanent resident. There are some working visa categories that are dual intent. The government doesn't care. H-1B, L-1, O-1. So that's going to be a big exception, and I know for the people I can see on this chat, this is going to be a big sigh of relief. Should be a big sigh of relief for you. When aliens who are inspected and admitted or paroled may request adjustment of status as a general matter, the discretionary approval of such a request is extraordinary, given Congress's intent that the alien should depart once the purpose for which they sought parole or a non-immigrant admission from DHS has been accomplished. Okay, fine. Um, non-immigrants to depart rather than pursue adjustments. Such aliens are generally expected to pursue an immigrant visa and admission from outside the U.S. if they wish to reside permanently in this country. While such aliens may otherwise be eligible for adjustment of status, this contravention of their expectation and attempt to avoid the ordinary consular process, usually accompanied by their violation of our immigration law. So remember, let's go back to the cowboy approach. Person, and these are not my clients because I shake them by the lapels and I don't let them do it. Uh, you enter the United States as a B1, B2 tourist visa. You're admitted for 6 months, but you never leave. It's been 2 years, 5 years, 6 years. You were admitted. You were inspected and admitted. That 6 months of entry was lawful, and then you are now unlawful. You were out of status. Uh, Under longstanding law, that overstay gets forgiven when the adjustment gets approved. What this policy memorandum is saying is that that violation of law may no longer be given the forgiveness that we have long counted on. I had a client uh, years ago. He was one of my earliest O1 clients. He had done some acting work, done some pretty prominent acting work, got a 3-year O1 visa. Uh, Around the 2-year, 2.5 year mark, that's when I start bugging people saying, "Hey, what are we doing? Are we going for a new O1 visa? Are we going for a green card? What's your plan?" He ghosted. He went MIA. I figured he moved home or maybe he passed away. I never heard. Years later, he out of the blue, he says, "Joe, 5 years ago." So let's do the time. He was admitted in like 11. He went out of status in like 13 or 14, and then maybe in 17 he emails me and says, "I met the love of my life. I'm a step father to her 3 children. We live together. We have a lovely life together. I want to normalize my status." All right. Under best prevailing practices at the time, we disclosed the fact that he had done some unauthorized work. We disclosed the fact of the overstay. Otherwise, it's a bona fide marriage. He goes for his interview. The interview went smoothly. He became a permanent resident of the United States, never departed the United States. And then a few years ago, he naturalized. He's a U.S. citizen now. If this policy memorandum is now the law, and again, this is going to be challenged, he would have been in real trouble. That overstay, that long overstay, if he departed the United States, would have triggered a 10-year bar on his reentry. Remember, if you overstay um, by a long period of time, upon your departure, you're deemed inadmissible for 10 years. A year of overstay, 1 year of overstay means the consequence is a 10-year bar on reentry. There are waivers. There are exceptions and ways to handle that. But if this policy memorandum is the law, I could not have given him that advice that I did, and he would have had a much tougher time. There's a lot of repetition here, uh, but uh, but but now we're getting into the exceptions. So so they're saying consular processing is the default, adjustment is exceptional. Uh, Immigration officers, you are supposed to show unusual or even outstanding equities. Equities is just another rule for fairness. Existing guidance directs officers to consider violations of our immigration laws or the conditions of any immigration status held, current or previous instances of fraud or false testimony in dealing with USCIS or any government agency, whether an alien's application for admission or parole violated the law, regulations, and policies in place at the time, or any conduct of the alien after admission as a non-immigrant or parolee inconsistent with the purpose that non-immigrant status or parole or with representations made to consular or DHS officers when applying for a visa, admission, or parole. Here's the big exception. So what they're saying is officer, U.S. CIS immigration officer, we're not getting rid of adjustment of status. In fact, I can show you right now. In fact, I want to show you right now that as of today, right now, if you go to uh, USCIS Gov, the Form I-485, a lot of you are familiar with Form I-485, application to register permanent residence or adjust status. This is the form that we use to adjust status. Now, go down here. It's a long, complicated form. And I'm not going to go through the whole form for you, but addition date. The last version of this form came out, it was the day Trump came into office, January 20th, 2025. They have not updated the form. They have not changed the form. They have not said you can't file adjustment of status. That is not what this policy memorandum is. And there's a lot of fear mongering and clickbaiting and TikTok lawyers. And by the way, TikTok lawyers, we should have a whole conversation about TikTok lawyers because they drive me nuts. Um, uh, Adjustment of status is still part of the law. Nothing prevents us from filing adjustment of status. What they're saying in this policy memorandum is if in the balance of things the person has violated immigration law, and by violation, I think they're meaning overstays. I mean, and then they said, false or fraud testimony. Well, fraud is a permanent bar to immigration status. So fraud or misrepresentation is like, that's like the electric chair in immigration. We don't do it. So why they threw that into this memorandum, I don't know. Um, and I guess maybe, false or fraudulent testimony in relation to something else, some other government application. Um, uh, Failure to comply with the conditions of their non-immigrant admission. I can maybe, so you're a student, you were here on a student visa, you didn't have work authorization, but you worked anyway. That's a thought. Uh, Maybe that's something that could be a factor. But again, just don't do it. Uh, USCIS reminds its officers that applying for adjustment of status is not inconsistent with simultaneously maintaining non-immigrant status in a category with dual intent. And I know that's jargony, but let me just repeat it and let me just explain it in plain English. USCIS reminds its officers, this is directing USCIS officers, that applying for adjustment is not in that double negative is not inconsistent with simultaneously maintaining non-immigrant status in a category with dual intent. So if you're here on an O1 visa or an H1B visa or an L visa and you're maintaining status by doing what you need to do on L1, H1, O1, and then you apply for adjustment of status, the double negative is interesting. It's not inconsistent. Why don't you just say it is consistent? Applying for adjustment of status is consistent with simultaneously maintaining non-immigrant status as a category of dual intent. We do this all the time. Someone's in the US on an O1 visa. They've got 6 months left. We file their I-140. The I-140 is approved. That gets their classification. We then file their I-45, the form that I just showed you. That is consistent with adjustment of status. Okay. Back to these exceptions. Adjudicators must weigh all positive and negative factors, including family ties, immigration, status and history, the applicant's moral character, and any other relevant factor that bears on determining whether the alien warrants a favorable exercise of discretion. Where I think this is coming in is them saying, okay, even if you came here on a student visa, or no, say if you came here on a tourist visa, you overstayed, you didn't work without authorization, you had, say, two or three children, maybe you have a U.S. citizen brother or sister, cousins, family members, you've never been in trouble with the law, no history of criminal activity. Um, hey, that warrants a favorable exercise of discretion. Grant the adjustment of status. So that's the policy memorandum. That's what's causing this concern. USCIS has said that they will come up with more, they will develop more details about these exceptions and what warrants favorable exercise. We'll see what they do. So that is the change. That is the rule that people have been texting about, posting about on the internet, getting very worried about. What does this do? As I sit here right now, having reviewed this all weekend and in preparation for today, if you've got an adjustment of status going right now, I don't think you change anything. I think you wait to see what happens. The officers themselves are going to be confused. Remember, it's the immigration officers, and there are thousands of them, who get to decide what warrants discretion and what doesn't warrant discretion. So if you're in the U.S. right now and you have a pending adjustment application, talk to your immigration lawyer. But until we have more information, I don't know that you change anything. If you're in the U.S. right now and you're in a normal status, HL, O, and your plan has been to file for adjustment at some point in the near future, I don't think this changes anything based on what I see. And worst case scenario, you file for the adjustment, and then maybe they issue a request for evidence saying, prove applicant prove that you're qualified for this discretionary relief, which we've never been asked to do. But I will just go back to this policy memorandum. Here are the factors. The person's never been arrested. Person's got a good moral character. Person has a job and work commitments, and making them leave the country and go through consular processing will be expensive and time consuming. It'll be expensive for their employer. It'll be very disruptive and stressful for their families or for their significant others. And let's see what they do. Um, and then, of course, let's see what the courts do. I do not think this is the kind of thing that survives court review. When Trump goes to court, he loses 95% of the time. When what the genesis of these policy memorandums in Trump 1.0 was Stephen Miller would get on the phone and yell at the high level career bureaucrats at the Immigration Service and tell them, you need to do this, you need to do this, you need to do this. And they said, well, we would try to do our best, but he was asking for things that we can't do. I think this is this issue. So that's all I have for policy memorandum for adjustment of status. So unless anyone has any questions about the policy memorandum or the change, I'll move on to any other questions that people might have. One thing that I always try to emphasize is that, and this is part of why I wrote my book. Uh, 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 Jesse says, "Thanks, Joe. You answered my question." Thank you, Jesse. I'm glad I answered your question. Um, One reason I wrote this book in early 2024, right? The election is in November of 24. In early 24, it's pretty clear it was going to be Biden versus Trump. If it was going to be Biden second term, the Biden administration, the Biden immigration service, not perfect, made some stupid decisions, litigated them in state court, in federal court, got some really good court decisions got some bad immigration decisions overturned by going to state court to federal court. Some of you might know about that case I had where the immigration service said that this man's Grammy didn't count as a Grammy. That was a Biden era immigration decision, and we got that overturned in federal court pretty quickly. Also, Biden era immigration. I had a case where a couple had gone for their marriage-based green card interview. It sat for 4 years. They were at the end of the process. They went for the interview. That's the end of the process. Normally, the immigration officer just says, "Yes, Mr. and Mrs. So and so, Mr. and Mr. So and so, your case is approved. Your green card will come in the mail the next few weeks." They said in this particular case, they said, we need a few weeks to review this and we'll come back to you. This is the case out of the USCIS field office in Houston. Not my case. No, another lawyer handled the case. She handled it very well, I thought. Every few months, she'd follow up, she'd follow up, she'd follow up. That went on for 4 years. It lands on my desk. We want to sue the government over the delay. We sue the government. The government gets 60 days to respond to our federal lawsuit. Within those 60 days, the government comes back and says, prove that they're still a married couple. And the first two pieces of evidence we supplied were the birth certificates to the two children who had been born in those 4 years. Case approved. So federal litigation, even in good administrations, is sometimes the route to go. Part of why I wrote the book is to emphasize the reality that changing U.S. immigration law is very difficult. The last time there was a big immigration bill was in early 1991. I was a little kid. Some of you on this call were not born yet. Immigration law is very hard to change. We've had it was a product of bipartisan compromise with a center-right president in George H.W. Bush, the father, and a sort of a center-left Connecticut Democrat, who was the chair of the committee. They worked out a deal, uh, not perfect, but not bad either. And that's what created the current system that we have. That's why we have O1 visas and EB1 green cards and TPS status. That's that law that was created in 1991. Since that time, there have been proposals to change immigration law. There was a pretty decent bill that Paul Ryan, then Speaker of the House, kind of Senate now by by today's standards, a center-right Republican, and Barack Obama. They had worked out a deal, border security in exchange for the Dreamers, in exchange for improving some of the procedures that we deal with. Paul Ryan couldn't sell it to his hardliners in his caucus. Immigration law that we have been talking about, O1 visas, H1B visas, employment-based and family-based green cards, they ain't going nowhere, folks. Not anywhere time soon. Lauren, you have a question for me. Um, Let me read the question and then I will respond. Lauren, what about for marriage-based green cards to remove conditions on residents that are currently processing? Very good question. Mine's been processing since November of 23, and they gave a 48-month extension to my expired I-551. Could this policy affect this kind of case? No. Let me explain, because there was some jargon in there, Lauren. Let me kind of explain for the audience what this is. So, when a marriage is less than 2 years old at the time of the filing of the marriage-based green card application, there's a string attached. You get a green card for 2 years. It's called a conditional green card. So, Lauren was a conditional permanent resident. The condition is that in 2 years' time, you have to file a joint statement saying that you're still a couple, that you're still in a bona fide marriage, or if one of three sad things happens, you have to file for a for an exemption, for a waiver. If the U.S. citizen dies, if the U.S. citizen committed domestic violence against the foreign national, this is one of then Senator Biden's laws from the 90s, the Violence Against Women Act says, and it doesn't just apply to women, it applies to everyone. You don't have to stay in a physically abusive marriage. Uh, uh, if you're being abused, get out of the marriage for your own safety, and then self-petition a Violence Against Women Act petition, so you don't stay in the marriage. Or if the marriage was bona fide, if the marriage was real, but it just didn't work out. Okay, so you file for a green card case. The marriage is less than 2 years old. Lauren then filed what's called an I-751 petition to remove conditions. Those cases are seen as very low priority by every immigration service because what they figure, Lauren, is that you're going to go for your citizenship anyway. So what happens in the past is they figure you're going to file your N-400, your petition, your citizenship application, then they'll match the 751 with the N-400 and then adjudicate both together. What you can do is file a federal case, a federal delay case. If you have that's kind of an extreme version and it's costly. But another thing you can do is reach out to your local member of Congress, ask them to put in a formal inquiry. There's the way the government sees it, and you may disagree with this. I disagree with this. Is there's nothing that you can or can't do with the extension that they give you when you file the I-751 petition to remove conditions. Your receipt notice becomes like a temporary green card that you travel with. Okay, so that's it. So, but your answer, could this policy affect this case? No, because you've already adjusted status, Lauren. Adjustment of status has nothing to do with 751s. Jill, do you think now is a bad time to go from O1B employment based to an EB1 status? No. My philosophy, and I've said this to every green card client who's ever crossed my path. When someone calls me up and they say, I want to become a permanent resident of the United States, or if they say, I want a green card. If you want to make the United States your home on a permanent basis, the time to start working on that case is now. That might mean paying a lawyer and paying filing fees and actively working on a case. It might mean just getting more evidence and organizing documents on your desktop, which costs nothing. But the time to start working on it is now. Is it a bad time to go from O1 to EB1? I I have never pulled a case. I have never advised anyone to delay pursuing their goals because of someone in the White House. If the government makes a bad decision, and they make bad decisions under Obama, under Biden, under Trump, they make bad decisions all the time. We can pursue the next steps. Remember as well, if you're denied, with the exception of fraud or misrepresentation, if you're denied an O1 visa or an EB1 green card, it's just because they don't think you hit the high mark they're looking for. Denial is without prejudice towards future cases. So the conservative strategy is just to try again. I think it's actually a pretty decent time. If anyone wants to talk about the issue of retrogression and priority dates, we can. But right now, and I'm sorry for the jargon, right now, EB1s and EB2s are current for everyone except for India and China. But we never know when retrogression is going to happen. Right before the pandemic, every green card category was retrogress. Remember when I said you have to file your I-130 or your I-140 to get your place in line, to get your priority date? Sometimes there's a backlog, which we call retrogression, where there are more people interested in the category than there are green cards available. Remember, there's a cap on the number of green cards that get issued per year. Right now, EB1 and EB2 are current. So, Jill, if it's, go for it, I think. Um, Elena, What would happen to people from 75 countries that are currently under a ban and on immigration pause in countries abroad? The practical effect, okay, so for people who don't know, there is a ban on immigrant, this is so racist and stupid. There's a ban on immigrant visa processing for certain countries, mostly countries from that are predominantly black and brown. Um, so they are pausing immigrant visa processing. So the solution is adjustment of status. Elena, you're a current client of mine. I have an answer, but I don't want to say something um, to violate our attorney-client privilege. Um, but we'll talk privately. I think you're going to be fine for adjustment. Um, Bronson, uh, do you now expect most marriage-based green card applications from J1 to be deferred to domestic consulates? Um, J1 visas are non-immigrant. Um, I don't see, I think it's too new. Uh, it's not that they're going to be deferred. You can still apply for adjustment of status. Nothing prevents you from applying for adjustment of status. And so if it's appropriate, if you meet the normal criteria for adjustment of status, I would say go for it and see what happens. You know what this reminds me of, and for those of you who've been around through the first Trump administration, one of the roadblocks that they hit us with was something called the public charge rule. The public charge rule says that if someone is going to be a burden on the U.S. government, on U.S. finances, then a so-called public charge, it's an old-fashioned term. If you're going to be a public charge, you are inadmissible. The classic example that they give is, say you are very poor and you require round-the-clock institutionalized nursing care. Okay, say you are someone with severe um, autism and you're confined to a wheelchair and you can't speak and you need 24-hour care and you have no resources, you might be considered a public charge. That was the old rule going back decades. What the Trump administration tried to do was create a rules very similar to this, very similar with this policy making. They shortcut the normal formal rulemaking process, and they said, okay, now you have to supply all your financial information, everything about your debt, your credit score, your educational background, not the I-140 stuff, not are you at the top of your field. This is in the family base. This is for everyone. And then in that soup of documents, and some of these ended up being, giant stacks of documents. Out of that, an immigration officer is expected to conclude that maybe in the future this person could be a public charge on the United States. That law was challenged in court, and then Biden won the election, and then the Biden administration didn't they basically just let the court challenges play out, and then they formally revoked the rule. That rule and reset it back to the old rule. This kind of reminds me of that. It's it they're the point of this is chaos. The point of this is to discourage people, not to actually change rules for the better or make the system work more efficiently or anything. The purpose of this is to cause frustration. So that well, those of you who know me know my know my politics and my feelings on the matter. We're at the 1 hour mark. If you have any questions and want to talk one-on-one, feel free to reach out. I'm always happy to do so. If you have any friends, colleagues who are worried about this matter or any other immigration matter, if you're seeing something in the news that's causing you stress, please reach out to me. There's so much gossip, there's so much rumor, so much bad information, and it's very hard to tell the good and the bad information. AI is not your lawyer. AI is not your doctor. Google is not your doctor. Google is not your lawyer. The USCIS.gov website is not very useful. I'll send a recording of this to everyone who signed up. Feel free to pass it along to anyone that you feel would be beneficial from it. And of course, I'll send you those resources as well. Everyone, deep breaths. We're getting through this together. Have a good day.